quiet courtroom morning quickly turns tense as one defendant after another faces the stern gaze of the judge. From a dirt bike feud to a chilling case of harassment, each story exposes a different kind of recklessness and regret. But nothing prepares the room for the moment when the judge's patience finally snaps at a man already out on bond for murder.
Thanks, sir. Sir, you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 16, 2025, the officers made contact with the complainant at a residence in Harris County, Texas, who stated the defendant came to the cul-de-sac on a dirt bike, began revving the engine, which got the complainant's attention, and the complainants began recording the incident on their cell phone. The officers reviewed a video from the cell phone showing the defendant sitting on a dirt bike, continuously revving the engines, and the complainants made contact with the defendant, and the verbal argument began. The defendant made the comment, "It's y'all asses. I know where you live. I got y'all." And the complainants feared for their lives, believing the defendant would return to cause them bodily injury. The defendant's residence is only 0.7 miles from the complainant's residence.
Judge, I think the facts are going to show this stems from a confrontation that the neighbors had with his children, and that there's more context to the alleged threat that explains that. However, my understanding is—
So are they next door neighbors?
No, they live in the same general neighborhood, but there's already a pretrial bond condition of no contact.
Got it.
And I've explained to Mr. Schreiber that staying away from them is good.
Really, that's all we're asking you to do. You know, you've got a great lawyer. Listen to him. He'll take care of you. I am going to find that there's probable cause to go forward with the case. Just don't have any weapons, don't have any contact, and all will be well. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Downey, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you've taken off, I'm going to issue a warrant for your arrest. Just don't pick up any new cases, okay? We'll have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thanks, guys. Please. Good morning, Mr. Humphrey. So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes,
You have
Judge.
the right to have an attorney present. If you're not afford one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight as they were in a dating relationship for 2 years. The complainant stated they ended the relationship in 2023, but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no-caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100+ times from a no-caller ID. The defendant spoke to the officer and admitted to calling the complainant 100+ times from his primary phone number and his secondary number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. I mean, really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works, no weapons. You know, life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just life's way too short. Really. You have the ability to hire a lawyer, Mr. Humphrey. Or do you need a court-appointed lawyer? Okay. Just, I want my community safe, man. That's all I want. Please, you know, please. I have an application on file already. So I'm gonna have you sign a release with Victoria. I'm gonna have you meet with police for your bond conditions. I'll provide you a lawyer here momentarily. Just think before you act. Come on. You were charged with criminal mischief. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Your lawyer is here with you on Zoom so that you know you're not alone.
Yes, Judge. On June 24th, 2020.
Hold on.
Yes, Judge. Yes, Judge. On June 24th, 2024, the officers were dispatched to a burglary at a warehouse in Harris County, Texas. The defendant and another unknown male were seen on a security camera approaching the warehouse in an SUV and gaining entry to the side of the building by pulling back two metal sheets that lead to two large holes on the wall. The complainant estimated the damages to be valued at approximately $800, and the complainant stated the defendant broke into the property to attempt to retrieve items that belonged to him. The complainant stated to have filed a civil lawsuit against the defendant for not paying rent.
Say it again.
The complainant filed a civil lawsuit against the defendant for not paying rent, and that the complainant was there to obtain property. Or the defendant.
Mr. Gibson, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Don't go back to this location. Do you understand? If you pick up a new case, if you go back to this location, I'm going to revoke your bond and put you in jail. No more PR bonds. Okay. Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Cedillo. JP, have you filed an attorney of record?
No, Judge, it's brand new. I'll get that done today, Your Honor.
Please.
Judge, I know you found PC, but just can you indulge me and can I just hear how how my client was identified? I did not hear that.
Surveillance video.
Yes, Judge.
Okay.
That's what they say.
I mean, is there any description that it was him, or did anyone say that it looked like my client or anything like that? Did the officer look at the surveillance footage?
Yes, the DIM states explicitly that the defendant is seen on security camera coming onto the property.
Okay. We'll take a
I
look
mean,
at
if you get the video, it shows something different, come back. I'm always ready to entertain anything at a later time, you know?
Of
Really.
course, Judge.
So,
Thank you.
but until that time, don't pick up a new case. Don't go back. All right. So Vic, you want to give me a date?
Yes, Judge. How is March 25 through the 27th?
Let me see, Judge.
Judge, was that state's bond conditions?
Yeah.
Okay.
Judge, March 25 will work.
Yes.
Okay, cheers. Okay, so for now, I'll have you sign a reset. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then you'll be free to go. Okay?
Thank you, Your Honor.
By the midpoint, emotions run high. The judge has warned, lectured, and pleaded for reason. But when a defendant accused of murder resurfaces with harassment charges, the tone turns grave. And just as order seems restored, the second half spirals into theft, assault, and tampering, testing how far mercy can stretch before justice hardens.
Mr. Caldwell, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle traveling 35 miles per hour in a 20-mile-per-hour zone on Pine Dust Lane. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle, and the defendant was not wearing a seatbelt. The officer further observed an odor of marijuana and asked where the marijuana was located. The defendant stated the marijuana was located in the back seat. The defendant gave consent to search the vehicle, and the officer found a clear plastic sandwich bag with a green leafy substance in the back seat and a glass container with a green leafy substance. The total weight was 0.921 ounces.
Okay, Mr. Caldwell, I'm going to find that there's probable cause to go forward with your case. Have you looked to see if he has a license?
It's not eligible, Your Honor.
Okay, you're not allowed to drive. If you don't have a license, do not drive. Do you understand? If you go get a license, if you get insurance, come back to me. I'll take this restriction off. That's your only condition. Don't get in trouble and don't drive. Do you understand? I'm going to have you sign an affidavit, which is a promise you're making to me. That's the only condition, Mr. Caldwell. Don't drive. Now, you have a lawyer Remain in contact with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get in contact with you, I will revoke your bond. Just don't pick him a new case and be good. All right? Come on. Thanks, Mr. Cole. Ms. Newton, you now stand charged with 2 more cases. You're charged with another theft case. You're also charged with failure to identify oneself to a peace officer. You are facing up to 6 months in jail and or a $2,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 17th, 2025, the officer was dispatched to JCPenney's regarding a theft or shoplifting. The officer made contact with the complainant, a loss prevention employee, who stated the defendant, Newton, and a co-defendant, Woods, entered the store, selected several items, put the items inside a personal bag, and exited the store, passing all points of sale without paying for the concealed items. The complainant stopped the defendants outside and escorted them back to the loss prevention office. While at the office, the defendant identified herself as Christiana Ray to the officer. An APHIS search came back to reveal the defendant's real name with an outstanding warrant out of Harris County, Texas. The total value for the items was $268.
She has a theft from December of 22, a theft from June of this year, of last year, and now 2 more cases. Was she on bond for either of these cases when she picked up the 2 new cases?
Let me see, Your Honor.
Okay. You are looking at Miss Newton here. Was she on bond for any of these cases, or were they all just in open status? It's 254, 8009.
Your Honor, it appears bond was made after the new cases. On the 19th, the new cases were picked up on the 17th.
In the court processing page, last name KOTUN, that's the original case, and there were multiple bonds posted on that one. A GOP and a surety, and then these other cases got picked up. So it's a 3rd name.
On the 251, it appears she posted bond only one time on the 19th of this month. On the 243,
Yes, Judge, on the 243.
that's the one that was
appears
in
the
current
GOP.
status, right?
Yes, Judge.
Where are all those from?
So the theft, cause number 243 was a Dick's Sporting Good. The
So Dick's,
Dick's, and then 251 theft was a Sephora, and then the most recent theft was a JCPenney.
Ms. Newton, Ms. Williams, I'm going to find that there's probable cause to go forward with the case. I'm now putting a monitor on your ankle so I know where you are at all times, and you are forbidden from going to JCPenney, any JCPenney. You're forbidden from going to any Sephora. You're forbidden from going to any Dick's Sporting Goods. If you pick up a 5th case, I tell you now, your bond is going to skyrocket. Do you understand, ma'am? Would you like to apply for a court-appointed lawyer, ma'am? Okay. I'm going to have you sign a reset with Victoria. After that, you'll get with Felicia for your bond conditions. Do not pick up a 5th case. I'm telling you now. I don't know what you're doing, but you pick up another case. You're also not to hang out with the other person, the co-defendant in this case as well. Do you understand? So can you reach out to the MAC for her, and then she'll have conditions with Felicia? Okay, please, ma'am. Morning, Mr. Price. Sir, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with a garden variety assault. On both of those, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The complainant, Terrell, and the defendant were in a previous dating relationship. The defendant followed complainant Terrell into a bathroom of a bar and began to slap complainant Terrell multiple times in the face, struck complainant Terrell with a closed fist multiple times in the face, and grabbed complainant Terrell by the throat but did not impede breath. The defendant would not allow the complainant to leave, and complainant Asher, friends with complainant Terrell, walked into the bathroom. The defendant struck complainant Asher in the face with a closed fist.
Who?
So complainant Terrell is the AFM and complainant Asher is the ABI.
Terrell, is that a?
That is a dating relationship.
Got it. Okay. Mr. Price, I'm going to find that there's probable cause to go forward on both of your cases, and I'm ordering you not to have contact with either person. Do you understand? On the family member case, I'm not seeing a protective order issued on Price. You see one?
I don't see one final data.
Okay, I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Terrell as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat of harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Pierwood Drive house. Do you understand? If you violate this court order, the state can and will file a violation protective order against you. It's one of the worst cases you can pick up. So you're also not to have contact with the complaining witness in the assault case and not to be in possession of weapons as well. We're going to file these conditions. You'll need to sign it. Did you need a court-appointed lawyer today, Mr. Price? Okay. You can reach out to the MAC. I've got an application on file. I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box while we get all your bond conditions. You'll sign it, and then we'll provide your lawyer here momentarily, sir. Please. Mr. Randolph, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine on that one. You're also charged with possession of marijuana. On that one, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle bearing a temporary buyer's tag with an expiration date of December 25th, 2024. The officer ran the expired buyer's tag through NCIC and observed the license plate to not be registered to any vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the front seat passenger. The defendant admitted to having printed the buyer's tag himself and putting it on the back of the motor vehicle. The defendant stated he printed the buyer's tag at UPS or something. The officer observed a strong odor of marijuana, and the defendant admitted to smoking earlier that day. A PC search of the defendant's person and vehicle were conducted. The officer located a small plastic bag containing a green leafy substance known to be marijuana based on training experience in the defendant's front right pocket, and a clear plastic bag containing marijuana in the center console of the vehicle. The weight was 0.3 ounces.
All right. Mr. Randolph, I'm going to find that there's probable cause to go forward on both of your cases. You look up to see if he has
It's not eligible, Your Honor.
We're not allowed to drive. I don't care what's going on in your life, Mr. Randolph. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, it's not going to go well for you. Do you understand? If you want to drive, go get a license, get liability insurance. If you can show me that you have both of those things, I'll take this restriction off. But I'm going to tell you now, if I find that you do, it's really not going to go well for you, sir. Did you need a lawyer today, sir? Okay. Let's see. Show file. I need you to fill out an application for me. I can provide you a lawyer today. Above all else, in the short life that we have, do not drive. This is an affidavit that you're going to be promising me you're not going to drive. Do you understand? All right, come on.
The courtroom hums with restrained tension as the judge begins her morning docket. Each defendant steps forward, a story etched in fatigue, regret, or defiance. The first, a man accused of harassment, claims a neighborhood misunderstanding. A dirt bike revved in anger, words thrown like sparks in the quiet cul-de-sac. The judge listens, weighing his defense, but her message is clear. Stay away, no contact, no weapons. The warning hangs heavy, a calm before the coming storm. Then enters the second defendant, Mr. Humphrey. His case begins as another harassment charge, but within moments, the atmosphere shifts. He is already out on bond for murder. The judge's tone sharpens, her words cutting through the air like a blade. She orders a GPS monitor, forbids contact with the victim, and delivers a chilling reminder. It would really suck to spend the next 50 years in a 6x9 box. Her plea is part warning, part mercy, urging a man drowning in obsession to swim toward reason. But the courtroom doesn't rest. Case after case unfolds, each one revealing another fracture in the human condition. Mr. Gibson faces accusations of breaking into a warehouse. The judge firm yet patient as his lawyer questions the evidence. A young man named Caldwell is caught with marijuana, his fate softened only by the judge's practical compassion. Don't drive until you're legal. Fix your life. Her words echo like a parent's final warning to a child teetering on the edge of ruin. Then comes Miss Newton, a repeat offender, tangled in a string of thefts from JCPenney, Sephora, and Dick's Sporting Goods. The judge, now exasperated, speaks with authority that borders on disbelief. If you pick up a fifth case, your bond will skyrocket. The tone is no longer patience, it's protection for both the system and the woman's soul. The crescendo rises with Mr. Price, accused of assaulting two people, one a former lover. The details are brutal, slaps, fists, and a chokehold in a bar bathroom. The judge wastes no time, issuing an emergency protective order. Her compassion has boundaries. Her duty to protect outweighs sentiment. Finally, Mr. Randolph faces charges of tampering with government records and possession of marijuana. He printed fake buyer's tags, a desperate shortcut that now costs him his freedom to drive. The judge looks weary but unwavering. Her closing words feel almost philosophical. In the short life we have, do not drive without reason or license. As the session closes, the air feels heavy with humanity, foolish, flawed, fragile. Each defendant leaves with a chance, small but still alive. And behind the judge's sternness lies something deeper, a desperate hope that at least one of them will listen, change, and choose peace before the gavel falls again.